Good morning, everyone. This trial is in the matter of case number TCD 001-2023, held before Justice Wayne Martin. Counsel for the claimant is Mr. Nathan Landis. Counsel for the defendant is Mr. Antonio Varvaro, instructed by Nurhan Azabi, advocates and legal consultants. Thank you.
Good, thank you. Well, thank you, gentlemen. We've obviously planned everything for this trial except for the weather, which is a very unusual event in Dubai. But hopefully we can work around it. And I think the proposal that's been put to you both, gentlemen, is that today we will restrict ourselves to the opening addresses. And then instead of going into the factual evidence today, we will do that tomorrow morning. And so we'll deal with the factual witnesses. As I understand it, the timetable proposal is that we'll have opening addresses today, and you can take as long as you need because we've got all day. Then tomorrow we will have the witnesses of fact. And then on Wednesday, we'll have the expert witnesses. And perhaps we'll come back to talk about the arrangements for the expert witnesses after I've heard you each in opening. That might be the best way to deal with that. So on that basis, then, are we ready to proceed with the openings?
Your Honour, there is one housekeeping issue, which is an
Yes.
application to extend time to file and serve. Yes, Your Honour.
Yes. Mr. Varvaro, do you have any objection to that application?
Not at all. It's fine with me.
All right, thank you. Well, that application is granted, Mr. Landis.
Thank you, Your Honour.
All right, would you like now to open, Mr. Landis?
Yes, thank you, Your Honour. Does Your Honour have the opening submissions dated the 6th of February?
I do, thank you.
Thank you, Your Honour. One minor housekeeping point that I realised as I was preparing is that the references and the footnoting is slightly out from the trial bundle, and I'll send through to Your Honour an updated version if that would assist.
Thank you. There's some other practical issues in relation to the trial bundle, and that is, for example, when I look at the factual witness statements, there are references to defendants' exhibit numbers without there being, and I don't know where I find those in the trial bundle, because the trial bundle, I think, is separately arranged. And then similarly in relation to the expert reports, the expert reports refer to a lot of documents, and I'm not sure how I'd find those in the trial bundle if I wanted to look at them. I just mentioned those two practical things, and perhaps, gentlemen, you might each turn your mind to how we can address that in due course.
Yes, Your Honour. It may be that we provide to Your Honour a I can't address, Your Honour, on the way the defendant's statements are structured, but certainly in relation to the expert reports, we can certainly provide to Your Honour a trial bundle index, which has pagination according to all of the appendices that are referred to by the experts.
All right. That would be helpful. Thank you.
Yeah, we can certainly do that for Your Honour.
Good. Now back to you, Mr. Landis.
Thank you. Your Honour, I don't propose to read the submissions onto the record. What I was going to do is to take Your Honour through and highlight probably half a dozen or so points that come out of the submissions. The first point that comes that I'd like to address, Your Honour, is paragraph 15, which is the reference to...
You're just breaking up a bit there, Mr. Landis. I missed that last sentence. Could you repeat that?
Of course. The first paragraph I'd like to take to Your Honour is paragraph 15 of the submissions.
Yes. Have you got a page number in the bundle for that?
I'm not sure they're in the bundle, Your Honour. The submissions, that is.
Yes, that's right. They're not. All right. Don't worry. I'll find them separately. Yes, I've got them now. And which paragraph are you taking me to?
Paragraph 15. It appears on page 5, Your Honour.
Yes, thank you.
And Your Honour will see that in paragraph 15, we say that we're relying on the expert report by Mr. Vimal Kasper Dev. The defendant in their opening submissions make much of the fact that Mr. Dev is an employee of the claimant. The submissions suggest it's something they only recently discovered through their own inquiries. In fact, Mr. Dev's report is open about the fact that he is an employee of the claimant, and his statement of independence acknowledges this matter, and he makes declarations to the court that it will not affect the opinions he's expressed. There's no basis for suggesting that Mr. Dev's conclusions are not based on his objective and expert assistance to the court or his assessment of the material that he's relied on reaching his conclusions. The declarations that I took Your Honour to earlier appear at, now, when I refer to the trial bundle, Your Honour, would you prefer me to refer to both the document number and the page, or just the page number?
Just the page number in the bundle is convenient, because that's what I'll normally be working from.
Thank you, Your Honour. And so his declarations appear at page 209 of the trial bundle.
That.
And there's no reason for the court not to accept those declarations as anything other than true, and no reason to not accept his evidence on its face.
Yes.
What that then leads to, Your Honour, is the point that's made at 16, which is that in the claimant's submission, the expert evidence doesn't assist the court in resolving the contract interpretation matters which are at the heart of this dispute. It does explain how events impacted the completion of the works and why they weren't attributable to the claimant, but it does not assist in that contract interpretation exercise.
Well, Mr. Landis, there's just a general point that I think applies to both sides, and that is that not uncommonly in construction cases like this, neither side really has paid a great deal of attention to what I would call the normal rules of evidence. So that, for example, in relation to the issues of delay, the witnesses of fact speak in extremely general terms. They all talk by reference to examples. Nobody purports to say, this is what happened on such and such a date. I wrote to them because this had happened. The closest one gets to any form of analysis of the facts relating to the issue of delay is in Mr. Dev's statement, where he basically refers to the documents and the conclusions he's drawn from the documents. Now, ordinarily, of course, the traditional rule, as I'm sure you're aware, Mr. Landis, is that expert witnesses are there to give opinions based upon facts established by other witnesses. There's been no attempt to do that in this case. And the other issue is that, again, both sides, I think, are proceeding on the assumption that the documents are evidence of the facts asserted in the document, so that if somebody writes to somebody else saying there has been a delay because, then that's not just evidence of the statement, but it's evidence of the fact asserted in the statement. Now, I don't mind if that's the conventional basis upon which we're proceeding. I'm not going to object to it, but I just want to be clear that both sides are proceeding on that assumption. That is, that the experts can, in fact, essentially give evidence of factual matters, or can, if you like, be relied upon as providing the documentary sources which are themselves evidence of the factual matters. And secondly, that correspondence is not only evidence of the communication, but also evidence of the facts asserted in the correspondence.
We've certainly proceeded on that basis, Your Honour.
Mr. Bavaro, do you have any comment to offer in relation to those issues?
Sorry, Your Honour, would you mind to repeat the question?
Yes. Well, I'm just pointing out that the traditional approach to evidence hasn't really been followed in this case. So the question is everybody happy for experts in effect to be giving evidence of factual matters, or at least their reports being used as the basis for evidence of factual matters? And secondly, that if somebody wrote to somebody else saying something, that is evidence of the fact, not just evidence of the communication.
Yeah,
You
it's
understand
okay for
that?
me. Yeah,
That's
I
okay
got
for you.
I got
All
your
right.
point. It's
Okay.
okay for me.
All right. All right. Thank you for clarifying that. Back to you, Mr. Landis.
And Your Honour, that also highlights another issue which the claimant, and I'm sure the defendant also confronts, which is the transitory workforce that exists in this country and the difficulties in securing witnesses from projects that were completed some time ago.
Yes. Yes, I understand that.
So we would urge Your Honour to adopt that pragmatic approach to
Yes.
how the evidence appears.
Right.
Dealing with paragraph 16, and Your Honour will see that there have 19 delay events listed out in 16,
Yeah.
which records with Mr. Dev's report. Drawing Your Honour's attention to a couple of the points that come out of 16. The first is that the defendant's entitlement to delay damages, so dealing with the counterclaim briefly, is under 7.4 in the contract, is conditioned on the requirement that the defendant demonstrate it's the claimant's failure to complete the works with the time for completion and that it's exclusively attributable to the claimant. And it's an important point that I'll come back to later on, but it is something that is a little unusual in construction contracts. Well, this contract has a couple of features that are unusual for construction contracts, but I'd draw Your Honour's attention particularly to that point.
Yeah. Well, there's another point, of course, and that is that, as I understand it, the defendant is claiming both liquidated damages and general damages for loss of profits.
Yes.
What's your
Your
position on that, Mr. Landis?
Well, the position on that is that it's simply not permissible. The parties have agreed a regime for damages, and if the defendant is not entitled to liquidated damages because of the way in which the clause operates, then we would say that they miss out entirely.
Thank you.
But the anterior point to that is that we say that you simply don't get there because the entitlement only arises if the claimant fails to complete the works within the time for completion. And time for completion is a defined term, so it appears in 7.4 as a prerequisite for the entitlement. And it's a defined term which Your Honour will see at page 2031 of the trial bundle. And that's clause 1.1.10 of the contract.
Yes.
And the words to focus on here are the words that are in the parentheses or as extended under subclause 7.3. And if Your Honour moves forward in the contract to 7.3, which is page well, it starts on 2037 and goes on to 2038.
Yes, I've got it. Thank you.
Extension. That's the extension of time provision, which is addressed later on in the written submissions. So the effect of an extension of time being granted either by the defendant or because one's been deemed by the operation of 7.3 is that the time for completion is extended and the occasion for 7.4 to operate simply does not arise. Looking at a couple of the delay events, and I'm only going to take Your Honour to a couple. And the first one that I'd like to take Your Honour to is over the page on page 6, the first one, which is the delay due to late approvals of variations. And you'll see that that has resulted in a delay of 606 days, and that is taken from Mr. Dev's report. The simple description of late variations belies a more complex consequence of a variation being approved late. And Mr. Dev outlines the variations that were issued during the course of the works, and they appear at Appendix AV to his report, which is at page 1463. If Your Honour turns to that page, you will see a chart which sets out the dates of the various variations. And Your Honour will see that in the case of the civil contract, variations were continuing to be issued in October 2021, and in the case of the MEP contract in December 2021. Under the contracts, variations must be approved promptly by the defendant. Clause 2.4 of the contract, which Your Honour will find at page 2033, top of the page, requires the defendant to approve or reject any submittals by the claimant within the time stated in the appendix. If Your Honour goes to the appendix, and please tell me if I'm going too quickly, I realise I'm
that's fine.
moving. Thank you, Your Honour. Your Honour,
So your last page was 2033, was it?
Yes, Your Honour, so that's clause 2.4.
Clause 2.4. Yes, all right.
Top of the page. And
yes,
Your Honour will see that it refers to a time stated in the appendix. So
yes,
if Your Honour goes forward in the contract
yes,
to page 2028, you'll see
5
a
days.
reference to
5
time
days.
for an employer to respond. Yes, Your Honour, precisely. The consequence of a variation being issued is that it pushes the balance of the works that depend upon that variation further along. This finally arrives at the testing and commissioning phase of the works, which obviously must happen last. The consistent picture is that the testing and commissioning phase of the works would take between 30 and 40 days. And I will take Your Honour to where that appears in Mr. Dev's report when we get to his evidence. The point here is that only once the substantive works, including any variations that go to that substantive work, is completed, that the testing
you just broke up again then, Mr. Mr. Landis, you just broke up again. I wonder if you could say that sentence again.
Of course. The consequence of a variation being issued is that it pushes the balance of the works that depend upon the variation further along. This finally arrives at the testing and commissioning phase of the works, which obviously must happen last, particularly the final handover. The consistent picture is that the testing and commissioning phase would take between 30 and 40 days. And when Mr. Dev gives his evidence, part of that evidence will include him explaining to Your Honour how he has plotted out the various programs and why the testing and commissioning will take that period of time. The point here is that only once substantive works, including any variations which go to that substantive work, is completed, that the testing and commissioning can commence and then final handover take place. That logical program must be taken into account when determining the extent of delay in the course of variations and indeed employer instructions. Mr. Dev outlines the longest path to completion based on this delay event. And that longest path appears at Appendix AA to his report, which is at page 406 of the bundle.
Yes.
That then feeds into the detailed program that Mr. Dev has prepared, which appears at the next appendix, AB, which starts at 408. And Your Honour will see in particular that the variations are brought to account at page 410.
Yes.
The final point that I want to take Your Honour to on that document appears at page 428, which is the testing and commissioning phase of the works.
Yes.
The next aspect of the delay events that I would like to address, Your Honour, orally is the roof. So the roof aspects of the project features in a couple of delay events, and Your Honour will see them referred to in paragraph 16L, which is the revised revised designs, and that's a delay of 473 days. And then again in S, which is the location of the FAHU, which is the fresh air handling unit, generator set and water tank, all located on the roof, which resulted in a delay of 308 days. The chronology of correspondence regarding the delay is set out in Appendix AN, that's Alpha November, to Mr. Dev's report, and Your Honour will find that at page 1268 of the bundle. And that's in relation to that first area of delay, so that's 16L. The correspondence regarding the delay event at 16S can be found at Appendix AU, that's Alpha Uniform. And it seems I've lost my cross-reference of that trial bundle. I will provide that to you shortly.
Okay.
If I can skip forward, Your Honour.
Sorry, I didn't read the appendices to Mr. Dev's report. Am I right in thinking that basically in those appendices he has attached the correspondence to which he refers in his report?
It is, Your Honour. So there is some, and this partly explains the length of the trial bundle. He repeats the correspondence. If it relates to 3 issues, it will appear in 3 appendices relating to each of those issues.
In his report, he sets out what he takes to be the documents that he relies upon for his conclusion that there was delay. All those documents are attached as an appendix to his report, are they?
Yes, Your Honour.
Oh, right.
Yes.
Well, that answers one of the questions I had earlier, I think.
It does to a degree, except the appendices are all identified as a single document in the bundle, as in, I think it's C5 is the document which has all of the appendices. And what I was proposing to do for Your Honour is to provide an aide-memoire which tells you where each of those appendices appear on a page number basis.
That would be very helpful. Thank you.
Thank you, Your Honour. Skipping forward to page 17, Your Honour. Your Honour will see there's a reference to early warning notifications of delay events.
Well, just before we leave Mr. Dev,
yes,
of course, Mr. Bowler has a number of criticisms of Mr. Dev, and I don't know if you want to deal with these now or later, but amongst the criticisms he raises, firstly, he says Mr. Dev has made no allowance for any delay occasioned by the claimant. And in that context, he says that basically his complaint is that Mr. Dev has simply taken the original program and then applied periods of delay as if that original program remained unaltered. And therefore, there is no occasion to take any account of any delays that might have been occasioned by the claimant. And therefore the analysis is unrealistic. And he says that a preferable approach would have been to take an as-planned program compared to an as-built, so that then you can see what was actually happening in relation to the project, and through that means you can identify any delays for which the claimant was responsible. And his second criticism is that Mr. Dev has effectively lumped the 2 contracts together. And Mr. Bowler says you can't do that. That's impermissible. You have to look at the delays in relation to each of the 2 contracts and identify the extent to which each delay was impacting either the MEP contract or the fit-out contract. Now, do you have any comment in relation to those 2 criticisms?
I do, and the second one is quite a simple response, which is that the program that by the parties was a single program which incorporated the 2 scopes of works. So it's not as if there was a separate MEP program of works and a civil program of works. So it's an unfair criticism of Mr. Bowler to say that the parties executed these works on one basis and then at the conclusion of the works say, well, you should have gone through and done separate programs for these and then analyse delays by reference to the separate contracts. In relation to the first criticism, I could come back to you, Your Honour, on that. I might have a think about how I respond to that.
All right.
Thank you, Your Honour. Your Honour will see at paragraph 69 that there is a reference to a number of items of correspondence, and that's on page 17 of the submissions.
Yes.
So there's what are called early warning notifications of delay events.
Yes.
There are those pieces of correspondence which we say would qualify as early warnings under clause 10.4 of the contract.
What's the significance of that? Sorry, what's the significance of that clause? Does it have to be, if it's not complied with, what are the consequences? Are there any?
The consequence is that if the delay event, it's to stop a contractor, Your Honour, from saying at point A, well, we've been delayed 6 months, and that started 6 months ago. So you now owe us an extension of time for that whole period. What it does is it prevents the contractor from doing that. If the contractor is not prompt in telling the owner, or indeed vice versa, or whether or not there's an issue of delay, then it prevents the contractor from claiming time and cost prior to that early warning notification. But Your Honour will see from the correspondence that there has been a significant amount of correspondence between the parties about the various matters that were occurring on this particular site.
Yeah.
And in addition to the letters that Your Honour has been referred to in the written document, I'll also draw Your Honour's attention to site meeting minutes, which were prepared by Al Halal Engineering Consultants. And these are picked up in the appendices to Mr. Dev's report.
Yes.
The minutes are important because they provide an independent verification of what is contained in the claimant's letters and put a different complexion on the letters that have been sent by the defendant throughout this period. One example is about the issues that are raised by the defendant on their 7th of June 2020 letter about blockworks in particular.
Yeah.
And that letter's been put forward as demonstrating that delays in the preparation or the completion of blockworks were caused by the claimant. All the photos attached to that letter demonstrate is that work was not done at the rate that was anticipated by the program. They're not evidence that any party in particular was responsible for that state of affairs. In fact, those meetings, the minutes of meetings that occurred around that time disclosed the situation. The first document I'd like to take Your Honour to is minutes of meeting number 18, which took place on site on the 18th of June 2020. And that document can be found at page 458.
Yes, I have it. Thank you.
Thank you. And if Your Honour scrolls forward to page 460, you'll see item 1 and the words appearing blockwork variations submitted on 27 April 2020 and revision 7 submitted on 7 June 2020.
Yes.
If Your Honour then scrolls forward again to page 480, you'll see that that's another meeting, minutes of a meeting for a site meeting that took place on the 6th of July 2020. Over the page on page 481, item 1 shows the variations referred to in the previous minutes with the statement that they've been approved on the 7th or the 9th of July 2020.
Yes.
Well outside the 5-day period that we look that is referred to in the contracts. Moving forward again to paragraph 72, which is the third EOT or EOT 3 as it's defined in the submissions.
Yes.
Your Honour will see that that document, and that document appears at 2721 of the bundle.
Yes.
when Your Honour sees that letter, you'll see that it seeks an extension of time until the 28th of August 2021.
Yes.
However, that date, that the extension of time that's sought, is based upon a number of assumptions that are set out in the letter about when instructions would be received or works by other contractors would be completed. In the event that those assumptions did not prove true, the date for completion would need to move accordingly. So it may not have been the 28th of August if events that had been assumed to occur in the future didn't occur when they were assumed.
Well, where does it say that in the? Can you just take me to the application? Because this is of some significance, because you, of course, place a lot of reliance upon the contractual provisions relating to extension of time, but
yes,
on the face of it, the only extension you sought only took you up to about 4 months short of the period at which completion occurred. So I think this is quite an important point. So can you take me to where those qualifications are to be found in this application?
Yes. So if you have a look at page 2722,
Yes.
which is a delay event 4.
Yes.
And you see that it's assumed that that delay event will finish with an instruction to resume works on the 20th of June 2021.
Right. Yes.
In fact, that instruction was not received until the 29th of September 2021. And Your Honour will see that within just that delay event, that the program dictated that the works would take 70 calendar days to complete once that instruction was received. And that statement appears at page 2724.
Just let me find that. So where do I find the 79 days in that page?
70 days, Your Honour. Just
70 days. Oh, there we are. Impact. Solid the cause and
Yes.
effect as per were 70 calendar days. I'm not following that. The impact was 70 calendar. Where does it say another 70 is required after the instruction?
Well, the impact is based on an assumption that the instruction is received on the 20th of June.
Right. Well, when the things that were anticipated to occur in this letter didn't occur, why wasn't it incumbent upon the claimant to make another application for an extension of time beyond the 28th of August?
Because, Your Honour, the variations that occurred after this time, well, there's a couple of reasons. The first is that employer instructions were given. So that employer instruction for that particular delay event was issued on the 29th of September and acknowledged on the 4th of October. And that acknowledgement said, well, we're going to take time to complete these works.
Do you have that? Is that in the bundle? The acknowledgement
It is, Your
on the 4th
Honour,
of October?
yes.
Can you take me to it?
It is. I can. If Your Honour then goes to page 2744.
Yes.
There's a reference in the second paragraph to the 40 days.
Well, that's not 70.
No, Your Honour, that's it demonstrates how the claimant tried its best to minimise the effect on the defendant with the delay.
So are you saying this letter is kind of a de facto application for an extension of time, or what is it? How does it work under the contract?
It's a response to an employer instruction to complete works. So the background to this is that these works had been de-scoped from the contract on the 4th of June 2021, and then re-scoped in by virtue of this instruction. So they become additional works, which has the effect of extending the time to complete the contract.
All right.
The next paragraph I want to take you on.
Well, that would take you up to early November.
Yes.
So how do you get to mid-December?
And then you want to recall that you have the testing and commissioning works that need to occur after the works are completed, which takes us through till late December. But because the claimant tried its best, it did it a bit quicker. And that's also in the context of other variations that are being issued as well while those works are being completed.
Okay.
The next paragraph I'd like to take your honour to is paragraph 96. Not quite sure what happened with the formatting here, but I'll read to you what that paragraph should say.
Yes.
The claimant relies on Article 888 of the Civil Code, which provides that the court may fix fair remuneration for the work done. And that, Your Honour, relates to variations which may not have been signed and stamped by the defendant, but nevertheless the work was completed.
Well, Mr. Landis, this I'm a bit confused about what exactly is an issue in this case, because really it's a claim for final account, isn't it? It's supposed to be.
Yes, it is. Yes.
And what I understand there's obviously an issue about delay. You claim prolongation costs as a result of the contract and it's common ground, obviously the contract took much longer than contract.
Yes.
The contract work took much longer. So the question is, who's responsible for that? You say the defendant, and therefore you're entitled to prolongation costs based on an extrapolation of the tender allowance for preliminary costs. By contrast, the defendant says, no, the delay was your fault, and they're entitled to both liquidated damages up to the cap and also general damages for lost profits during the time that they were unable to operate the restaurant. I understand all that. What I don't understand is the other elements of the account, and in particular the claims for variations, because it's not clear to me what variations are disputed and on what basis. Where do I find a convenient statement of the dispute relating to variations?
This is one of the issues, Your Honour, is that the defendant hasn't gone to print on which variations it challenges. We know that there are some that have not been paid. They haven't been rejected. They have sit in a limbo land. What I was proposing to do, Your Honour, is to provide an aide-memoire which sets out where all of the variations sit within the trial bundle, so Your Honour can see which ones have been approved, as in signed and stamped, and which ones sit. We call them under review because they haven't been approved and they haven't been rejected.
Well, I went to Mr. Bowler's quantum report to try and find a statement of exactly what is in issue, and he's taken, as I'm sure you're aware, he's taken your client's statements of final account and then marked them up to show the points at which he disagrees. Now, I couldn't see clearly from that what his position was in relation to the variations. Does that provide any insight into that? But there are other issues there in relation to, for example, there are other items of the account that are in dispute, and there seem to be differences, for example, about deductions and credits and things of that sort. So I guess what I'm looking for is a convenient statement somewhere, just really what the issues are. And given it's essentially a claim for a final account, that's probably a pretty good place to start to find out what the issues are.
Yes. Well, it seems on Mr. Bowler's report that the only issue with variations on the MEP contract is whether or not they should be exclusive of VAT or not.
Right. Well, that's the other question. Another question I had for you is your claim inclusive, the dollars, the dirham in your claim, are they inclusive or exclusive of VAT?
Inclusive, Your Honour.
They're inclusive of
Inclusive.
VAT. Okay. Yep.
And on the civil contract, it seems that the difference between the parties is simply this issue of what variations were approved and which were not. There's no analysis of whether the work that was done includes that what's been claimed in the variations, which is the Article 888 aspect.
Okay. Okay. And do we know which of the variations are an issue on that basis?
That will come from this table that I mentioned to Your Honour earlier. So I think that will answer the question. I'll need to verify the figures, but I anticipate that will highlight the particular variations for Your Honour.
When do you think you might be able to prepare that, Mr. Landers?
It's in draft. I just need to settle it. I ran out of time this morning.
All right. Well, if we finish early today, as we probably should, then you can spend some time doing that later today.
Yes, thank you, Your Honour.
Yeah.
And that, Your Honour, actually leads me to the next point, which is the claim for variations. So Your Honour will see that I've quantified at paragraph 112 and 113 both the number of variations and also what remains outstanding.
Yes.
Going back to one of the points that Your Honour made earlier about this is a claim about a final account, and the difficulty that the claimant has is that the defendant has not ever gone through on a line-by-line basis and said, we agree with this, we disagree with this, this is why we disagree with this, we agree with that, which is what the contract requires them to do. And that's one of the reasons that these proceedings were commenced, simply because the claimant wasn't able to get that basic information out of the defendant.
Yeah. Well, to the extent that the variations are an issue, what's the evidence upon which you rely for those variations?
Having been completed.
Yes.
Well, it's probably looking at it a different way, Your Honour, which is that the claims have been made and there's been no suggestion by the defendant that the work wasn't done. So going back to it being a statement,
isn't that why isn't that a reversal of the onus?
Well, because it comes down to this is a statement of final account case. It's not for the claimant to prove that the work was done. They they've completed the project, they've handed over, they've presented their statement of final account. The contract requires that the defendant says, hang on a minute, you haven't done that work. You're not entitled to claim that amount on your final account.
Well, another way of looking at it is this is a lump sum contract, and so you're entitled to be paid the amount specified in the lump sum, and that's all, unless you show that you did work over and above that which was included within the lump sum. So why don't you carry the onus of proving, firstly, that you did work outside that which was required for the lump sum, And secondly, that you're entitled to payment for that work because the provisions of the contract relating to variations were complied with.
Certainly, the contract provides more than just variations as a mechanism for an increase in the value of the work done. So, for example, an extension of time will entitle the claimant to the prolongation costs associated with that extension of time. But
yeah, well, let's leave delay out for a moment. Let's just talk about the variations.
Yes, Your Honour. It may be, Your Honour, when the evidence is finished that we are forced to abandon aspects of our claim.
Yes, all right.
I went through it a bit quicker than I thought I would,
Yes.
but unless Your Honour has any further questions, that's the opening of the claimant's case.
Well, just a couple of other matters. In relation to some of the areas of delay, there's an issue about who was responsible for getting approvals. What's your case on that?
So the approvals, the requirement for the claimant to get approvals is for the work. So it's capital W work within the scope. The defendant is responsible for the design. So where the design requires an approval, for example, from Dubai Civil Defence or Dubai Development Authority, that's an approval of the design. It's not of the work that the claimant was required to do. So for shop drawings, there may have been a requirement to get them stamped as well. But what we say about the approvals is that where the obligation on the defendant was to provide a stamped design, which is the appropriate approvals, then that's not within the obligation of the claimant.
Well, what do you say about clause 2.2 of the contract? I'm just trying to pull that up.
That's on page 2032, Your Honour.
Thank you.
So the obligation there is to obtain permits, license and approvals which are required for the works, and works is defined earlier on that page. All the work and design, if any, to be performed by the contractor. So design's been excluded by this contract, and Your Honour can see that in clause 5.0.
Right.
So it's a little bit circular. So the responsibility for design, which is 5.1 on page 2035, contractors responsible for design and design under this clause 5.0, and to the extent specified in the appendix. And if Your Honour goes back to the appendix,
yes,
you'll see on page 2028, about halfway down the page, contractor design.
yes,
And it's not applicable.
right, okay.
So the claimant's position is that it wasn't required, and indeed nothing in the correspondence suggests that the defendant thought the claimant was required to approvals from organisations such as Dubai Civil Defence or DDA for the design that the defendant was preparing. Once that design is provided to the claimant and shop drawings are prepared and if necessary approvals are obtained for that, then yes, those are the sorts of approvals that the claimant would be obliged to procure, but not for the design itself.
Yes, all right, thank you. One more question I've got is in relation to your claim for interest, and you claim contractual interest, interest
Yes.
rate of 15% under the contract. When do you say that that interest should start to run, because again, and one of the points made by Mr. Bowler is that you haven't identified the point in time at which you say particular amounts should have been included in progress payments. So
Yes.
is your case that you should get interest from the date at which the progress payment should have been made? And if so, is there a schedule setting out what you say should have been paid and when, or are you taking a more macro approach?
We've taken a more macro approach, Your Honour. It's we certainly, at least not my understanding of my instructions, is that it's been, for example, a payment application was made in May 2020, but not paid until much later on in the piece. The claim, as best I can understand it, is the 15% is calculated from when the statement of final account was due and payable, rather than look back into the project.
And what is the date once you say that the statement of final account was due and payable?
So 15 days after it was delivered. So it was delivered on the 19th of December 2022.
Right.
And goes forward 15 days from there.
Good. All right. Thank you. All right. Well, I think just let me check my notes, Mr. Landis. Yes, well, they're all the questions I have. Mr. Vivaro, it's now your opportunity to open. We've been going for almost an hour now. Would now be a good time to break for, say, 10 minutes before I call upon you?
Okay.
All right, sure. Why don't we adjourn and then resume at 11 a.m. in Dubai time then?
Thank you, Your Honour.
Just leave the lines open, perhaps turn off microphones and such like. Okay. We'll resume at 11. Thank you.
Thank you.
Thank you. Are we ready to resume, gentlemen?
Yeah,
yes, Mr. Vivaro, over to you.
Thank you, Your Honour. On behalf of the defendant, I'd like to focus on a specific matters which have been highlighted by my esteemed colleague, and I'd like to give our point of view, so the defendant perspective. In particular, let me say that, broadly speaking, we believe that the ultimate and crucial aspects of this case is referred to the final account, and if the delays and approved variation are considered or not, are to be considered or not.
Yes.
I'd like to highlight one point, that the claimant was contractually had an obligation, which was to follow the MERAS manual. MERAS manuals gives to the contractor clear instructions about the works which are to be to make, so to process. And this MERAS manual has been constantly and several times has been not followed. In particular, I'd like to refer before quoting some clauses of the contract, which, in my opinion, are of paramount importance, and specifically the clause 2.2 of page 2032. Page 2032 of the trial bundle. The contractor shall obtain all the permits, licenses, and approvals which are required for the works.
Yes, well, you heard Mr. Landis's submission on that. He says that works is a defined term, and if you go, that's up the page, means all the work and the design, if any, to be performed by the contractor. Now, he says that because the appendix provides that there was to be no design performed by the contractor, that means that he had no obligation to obtain approval for design. What do you say to that?
I say that we disagree about this sort of interpretation, and I'd like to also, in addition, to draw your attention on page 2828 of the child bundle.
So which page was that again?
Which the D47.
So which page?
The page is 2828.
2828, all right.
47, where according to an email which was sent by the CEO of the defendant company, it has been clarified that any variation is to be must be signed and stamped by the defendant. So
right, but that doesn't answer my question in relation to design approval. You say you disagree with the submission, but I don't understand why. Why do you say that the claimant was obliged to obtain approval for designs that were performed by your client?
According to the clause which I mentioned earlier.
But I just took you through the argument. The argument is that Clause 2.2 obliges the contractor to obtain approval for the works as a defined term. The works are defined to include the building work and the design work, if any. But if you go to the appendix, the contractor wasn't obliged to carry out any design work.
Yes,
so why then? So if your client was doing the design work, why should the contractor carry the burden of obtaining approval for design work performed by your client?
But the design had to be ratified in accordance with the manual. So it's not. There is no discretion of the contractor in relation to the design. And
sorry, I don't understand. Can you repeat that? I don't understand that at all. Can you just repeat what you said?
The design had to be rectified in accordance with the manual, MERAS manual.
But your client was responsible for design.
Responsible for design. The design was made by the defendant. So the design was made by the defendant, not by the claimant. The claimant is responsible to ensure that the design were rectified and approved by specification. This is
sorry, I'm just not following it. Your client was responsible for design, and then the contractor was responsible for building in accordance with the design.
Exactly.
So what's the point you're making about the what's the point you're making about the MERAS manual? Because the designs had to comply with that manual. Your client was responsible for the design. So why do you say the claimant was in somehow? What's the point you're making about the manual?
Okay, the point is the execution of works were not according to the design and according to the MERAS manual, as the witness report showed, and we will see. We will have the opportunity just to examine the expert report, and we will ask. And we will ask.
Well, you'll have to. I'm aware that that's the general allegation. So the allegation is not about design. The allegation is that they haven't constructed in accordance with the MERAS manual. But that will have to be made good by specific. You'll have to take me to specific instances and established by evidence that that's the case. It's not good enough for somebody to come along and say, "Oh, they didn't do the work according to the manual." You'll have to go down into the detail and say in what work and in what respects it did not comply. And I can't. Where do I find that in the documents that you've filed in this case?
In page 2694.
Sorry, 2694. Let me just go to that.
A letter sent to the 2694.
Yes.
2694. You can find a letter notification, and where there are notification about the works that.
Yes, well, that's an allegation that work hasn't been done. Where's the,
Let me see.
where do I find, is there any allegation in there relating to non-compliance with the MIRAS manual?
The MIRAS manual is so I mean a general agreement which they signed. It's not reported in any time that the parties email and so forth. It was the main agreement between the parties.
I understand. I understand the MIRAS manual is an appendix to the agreement. What I'm asking you is, where do I find your case to the effect that the claimant did not construct in accordance with the requirements of the manual? And the letter that you've taken me to doesn't seem to mention the manual. It refers only to delays in the performance of the work.
Let me check if I can find this point exactly. Just one moment. It is clearly stated in the expert report.
Where?
Not in the letters, where I will try to find the point. The expert report. There are different sections. Just one moment, Your Honor.
Sure. No, we've got all day, Mr. Vivaro, so take as long as you need.
Just one moment, I will try to find. Actually, I have some difficulties to find the point of the expert report, but I'm sure that I will. Actually, right now I can't find this point. Which,
all right. Well,
anyway,
it's something I need to know, because I at this stage I don't really understand your case on this issue. So it's something that you could perhaps, again, you'll have time this afternoon. Perhaps if you can answer my question first thing tomorrow morning, that would be fine.
Thank you. Thanks a lot.
Thank you. Now back to you, Mr. Vivaro.
So the point was the articles we rely on are, I mentioned already clause 4.1. The contractor shall carry out all the works properly in accordance with the contract, page 2023. And we believe that the works have not been properly made because, once again, they've not followed the instructions included in the MERAS manual.
Well, as I say, that's the part of your case that I don't presently understand. So I need some detail on that.
So the page 2023. Did you find it, Your Honor?
Yes, 2023, clause 4.1,
Yes.
2033.
Exactly.
Yes. Well, I understand the obligation. What I don't understand is the detail of how you say it's breached. Now, I understand that you say that the works were incomplete in the sense that there was a snagging list that you say the claimant didn't complete, that you completed, and you claim the cost of that. But in addition to the snagging list, do you say that there were other aspects of the work that weren't performed in accordance with the contract, and if so, what are they?
For these technical matters, of course, we rely on the expert report, and we supposed that this matter be analyzed properly and during the examination and the cross-examination of the witness expert. That's right. Why on these technical matters, maybe I am not exactly ready for this reason. So I focused on the legal matters, of course.
All right. Before the experts give their evidence, I'd like to know what your case is, and I don't presently understand what your case is. So I'd like to find that out before they give their evidence, rather than in the course of their evidence. That would be helpful.
The case, yes, the case is related to no compliance with the manual, as I said, and the delay in the works, and the not approval of many variation, approval of many variation, and these are the points which are related to our defense and our counterclaim. Because
right, well, I'd ask you the same question I asked Mr. Landis in relation to the variations. Where do I find a clear statement of your position in relation to each claimed variation? You don't seem to have identified what your position is. Do you say that the work wasn't done? Do you say that the work wasn't a variation because it was included within the contract? Or is your only line of defence to the effect that it wasn't approved? And if you say it wasn't approved, is it because it wasn't stamped and signed? In other words, is it a technical issue about the form of the documentation? Or do you say you didn't approve it at all? Now, I just don't understand I don't know what your case is. There are lots of variations, and I don't understand what your case is in relation to each of them. Where do I find a statement of that case?
The main complaint is related to the late execution of the works, because the parties agreed to complete.
Yes, I understand that, but I'm talking at the moment about the variations.
The works have been completed, even if after a long time, so in 531 days rather than in 123. So have been completed. The matter is not related to the final account, but the final account should be reviewed in the light of what has happened during that period, because it has caused as well a damage, a loss of profits to my client.
Mr. Vivaro, that's very interesting, but it's not the question I'm asking you. Let me repeat the question. The question is in relation to the variations. We know that the claimant claims a significant amount of money in relation to variations. What we don't know is why you dispute those variations. Now, there are a number of possibilities. One is you say the work wasn't done. The other is that you say the work was done, but it's within the scope of the work that the claimant was required to perform in order to earn the lump sum under the contract. Another approach is to say, well, the work was done and it was a variation, but the claimant's not entitled to payment because we didn't approve it. And in terms of approval, there are two options. One is, well, we may have said to the claimant, go ahead and do the work, or we may have, but without signing and stamping the approval. And you say, therefore, because there is no signed and stamped approval, the claimant's not entitled to payment. Now, what I don't know is what your defence is, which of those defences or any other defence is taken in relation to which variation claims. So I need to understand at some point why you dispute the variations, and I don't presently understand that.
Well, I'd like to say that work, in our perspective, work doesn't align with MERA's manual, first of all, and also
that's a different issue. So that's a different issue. That's the issue I've already asked you about, and you weren't able to answer. You weren't able to tell me in what respects the work didn't align with the MERA's manual. But that's not related to the variations, I don't think. That's a complaint about the contractual work generally. I just would like you to answer the question I've asked about the variations.
We can find, if we go to page 2420, 2420,
yes,
section D, D18,
yes. 2420 is a letter.
No, the page number is 2420, 2420.
Yes, it's a letter dated the 24th of June.
Okay. And this is a letter which was sent by the defendant to the claimant on 24 June 2020, when
yes.
So it was supposed the work could be or had to be delivered, completed in July of the same year, and where the CEO of the CEO of the defendant company pointed on some defects or not defects which had been found. So,
but I'm asking you. Can you? I just go back to Mr. Vivaro. Can you answer the question I've asked you about variations or not?
Yeah, as I said, our reaction is that we believe that the amount which is claimed by the claimant should be reconsidered in the light of the execution of works and in the light as well of the delay. This is our defense. This is our point of view. So,
right. Well, I've asked the question twice and you haven't answered it. So I assume that means you can't answer the question on variations.
I suppose that respectfully speaking, I suppose that I already asked. I already answered. So I answered.
Well, you haven't answered, Mr. Vivaro. With respect, you haven't answered the question at all. You've talked about delay and you've talked about non-compliance with the MERA's manual. But I've asked you twice for a clear statement of what your position is in relation to the variation claims, and you haven't been able to answer it, and it's not anywhere to be found, as best as I can see. It's nowhere to be found in your defence or counterclaim either.
As I repeat, that the work was not considered as a variation because they are already in the drawing of Maras manual and in the contract. This is our point.
All right. Well, I don't regard that as an answer to the question, but we can come back to that.
Okay. So basically, we believe that the claimant is not entitled to the amount claimed for the reason which I try to explain, and for the reasons which will be under a technical point of view will be explained by the expert, and on the opposite side, we complain, or on the opposite side, we have a claim of a counterclaim about the damages which due to this delay in the execution of.
Well, Mr. Vivaro, that's the next question. How do you say you're entitled to both liquidated damages and delay damages in the form of loss of profits?
Liquidated damages.
Liquidated damages are an estimate of the damage suffered. The parties have agreed that the damage that they will suffer by reason of delay in performance of the works is to be measured in the way specified in the contract. Now that, of course, is in place of any other claim for damages for delay. You're claiming both. You're claiming, as I understand it, you're claiming both liquidated damages and lost profits by reason of delayed occupation. Now, my question is, how can you do that? How can you claim it both ways?
Well, my client supposed that everything was ready in summer of 2020, you know. So it, let me check. In summer 2020. So that was the plan was to make a entertainment center. So, and the loss of profits is very clear. Also,
yes, but Mr. Vivaro, I'm not asking you about the facts. I'm asking you about the law. As a matter of law, how can you claim both liquidated damages for delay and general damages for delay? And do you have any authority to sustain the proposition that you can have both? Are there any cases you can point to that say you can have both?
According to my knowledge of the contract, there are no liquidated damages included in the contract.
There's a provision for liquidated damages. It's a daily amount. I think it's 10,000 under the MEP and 5,500 under the fit out contract, up to a cap of 10% of each contract. And the total amount, I think, available as a consequence, when you combine the two contractual amounts, the total amount is around 880,000 dirham in total. Now, you're claiming, as I understand it, you're claiming the 880,000 dirham, and you're also claiming lost profits during a period of 12 months delay. Now, my question is, how can you have both? I don't understand, as a matter of law, how you can have both.
The loss of profits have been calculated, and there is also a reasoning for that, about that computation, and so it is considered. It has been considered on the activity which the defendant has started later on, and so it is considered that during the period starting from July 2020 to December 2021, the loss of profits.
Well, Mr. Vivaro, all you're doing is repeating the claim. You're not explaining it. Again, I understand the claim, so nothing you've just said is anything new to me. What I don't understand is how you can claim both liquidated damages and general damages. If you can't explain that,
Okay,
my present view is that you can't. But if you want to argue that you can, you're going to have to explain that to me, and you haven't yet.
Yeah, in our skeleton arguments, in point 61, it's point B is explained why 10% of the revised value. So we claim 10% of the total agreement of the total project and the revised value, and referred to both contracts. So basically, the claim is referred to the two contracts which the parties have signed. So 10%.
All right. Well, let me just clarify that. So is it right that you're only seeking liquidated damages? You're not claiming for loss of profit.
The liquidated damages.
But see, that's if you go to, I've just gone to paragraph 61, you're claiming in B, you're claiming 10%, and then you're also claiming loss of profit in C of almost 2 million dirham. My question is, how can you get both?
We believe that the liquidated damages are related to the not to the loss of profits, but are related to the problem caused by the claimant to the defendant during the execution of works and for delayed execution of works.
Right. Well, Mr. Vivara, I don't want you to be under any doubt about this, so I'll state it clearly for the transcript. I don't presently see any basis upon which you can claim both liquidated damages for delay and loss of profits by reason of delayed occupation. If you're going to maintain that claim, you're going to have to provide me with some legal basis for that claim, because I presently can't see it. And I've asked you that a couple of times to justify that, and you haven't been able to. So sometime between now and Friday, you're going to have to explain that to me, or that claim will fail.
Well, Your Honor, I believe that the claim for loss of profits is can be combined with the liquidated damages for the reason that
whether you believe it or not doesn't really affect me, Mr. Vivara. What I want you to do is to explain to me as a matter of law how you can have general damages as well as liquidated damages. And stating what you believe is not very helpful to me. What I need you to state is legal propositions. Under the law of the UAE, can you get both? Okay.
Yes, if we can take a break, I will look for the point.
Well, I don't think we need to do it on the run. You can tell me tomorrow morning or Wednesday morning, but sometime between now and the end of the week, you've got to tell me the answer to that question. Okay. Because I don't presently see how you can get both.
Okay. Thank you.
Anything else by way of opening, Mr. Vivara?
No, it's okay. I'm over.
All right. So what I really want to hear from you sometime is three things I think have emerged. Firstly, I want you to tell me what your case is in relation to non-compliance with the MIRAS manual. So I don't understand that. Second thing is I want to know what your case is in relation to the variations. Upon what basis do you oppose the variations? And the third thing is I want to know what your case is in relation to the point we've just been talking about. How can you claim damages for loss of profits as well as liquidated damages for delay? So they're the three questions that I really need you to answer as soon as you can, but certainly during the course of the week. Right? Okay, thank you. All right. Now, is there anything else we can usefully do today, gentlemen? There's a couple of things, practical things, if Mr. Vivara, you're finished. Firstly, in relation to the evidence tomorrow, we'll start at 10 a.m. in the courtroom because I can see some blue sky looking out my window now, so I'm thinking the rain hopefully will stop, so we'll be able to resume in the court tomorrow. Will we need interpreters for any of the witnesses tomorrow?
No, we won't from our side, Your Honour, although I should flag that my witnesses live in other emirates. So although it might be clear where they're here, it may not be that the roads are trafficable. But it's something I'll liaise with the court to make sure they're updated on what that situation is.
Thank you, but you don't, Mr. Vivaro, do your witnesses, any of your witnesses need interpreters?
Yeah, they are here in Dubai.
Okay, but they don't need interpreters, they speak English?
They speak English,
yes,
of course.
Yes, good, all right. Now, in relation to the expert evidence, I think we had a brief discussion about this before, but the question is whether the expert witnesses should give their evidence in sequence or concurrently. My view is that it would be of great assistance to me if they gave their evidence concurrently. That is, if they gave their evidence together. There are various forms in which evidence can be given together. There's a spectrum of ways in which you can do it, as you may be aware, gentlemen. At one end of the spectrum, there is the full-blown concurrent evidence where there is an agenda of issues that are gone through and the experts ask questions of each other and so forth. I'm not sure that's the best way in this case. There's another way that that I've used quite often that I find is quite convenient, and it's a sort of a midpoint in the spectrum. And the way it works is that the expert witnesses are sworn at the same time. So in this case, Mr. Dev and Mr. Bowler would each be sworn to give evidence. They then have the opportunity to make an opening statement of about a half an hour, up to a half an hour, saying what they've done, the approach they've taken, and they can support that opening statement with any documents they want, any demonstrative exhibits. So if they want to produce a slide deck showing what they've done and how they've approached it, that's fine. But if they do want to use a demonstrative exhibit, that should be provided to the other side no later than the day before they give their evidence. And perhaps if they're giving their evidence on Wednesday morning, we should say no later than 3 p.m. tomorrow. So if they wanted, so then each gives a statement for up to half an hour. Then normal cross-examination takes place. So that Mr. Vivaro, you would then cross-examine Mr. Dev. During that cross-examination, I can ask questions as well if I don't understand the answer. And I can also invite Mr. Bowler to comment on any answer that's been given. All right, and then at the end of that process, then Mr. Landis will cross-examine Mr. Bowler and the same approach will follow. That is, I can ask questions of Mr. Bowler or I can invite Mr. Dev to comment on what Mr. Bowler has said. Then at the end of that process, there's an opportunity for me to ask additional questions of each of the expert witnesses. And then there's an opportunity for the experts to ask questions of each other, so that Mr. Dev can ask Mr. Bowler questions, Mr. Bowler can ask Mr. Dev questions. And then the final step in the process is that you each get the opportunity to re-examine. So then Mr. Landis, you would get the opportunity to re-examine Mr. Dev, and Mr. Vivaro, you would get the opportunity to re-examine Mr. Bowler. So that's how I'd like to approach the evidence on Wednesday. Gentlemen, do you have any comments or submissions in relation to that?
It's eminently sensible from my perspective, Your Honour.
Mr. Vivaro, are you happy with that course?
I am happy if we agree with the concurrent examination with the experts.
Good. All right. Well, that's the course we'll follow on Wednesday morning then. We'll need to make arrangements in the courtroom because I'm sure we can do it logistically. I've had a look at it, so we can put one of the experts in one of the witness box and the other in where the transcriber sits, but I'm sure we'll be able to organise that. All right. Is there anything else that we can usefully discuss today then?
No, I've got a bit of homework for Your Honour that I'll.
Yes. Well, I think you've given you both a bit of homework. So as soon as you can get any of that material to me, that'd be good. Otherwise, we'll adjourn now until 10 a.m. when we'll resume sitting in person in the courtroom. Mr. Landis, if there are any problems with your witnesses getting access to Dubai, let us know and we can deal with that logistically.
Thank you.
All right. Well, thank you both, gentlemen. I'll see you both
Thank you.
tomorrow morning at 10 a.m.
Thank you.
Good. Thank you. Today's adjourned. Thank you.